everyone. Just want to talk a little bit about the HIPAA regulations. I know you have some information in your text this week about just general rule making, and you obviously have some readings about security. I don't think you have much about privacy, but I think just from a regulatory standpoint in the healthcare world, I think it's important to understand HIPAA and its importance. So. I don't want to take a lot of time, but I just want to touch on there are a multitude of HIPAA regulations, but I do want to touch on privacy and security because that's really what we're going to be uh, talking about this week. So hopefully you can see my screen. This document that you have here is in your readings as well as the next one that I'll show. I'm not going to read this to you. You can obviously read it, but I just want to touch on a few things. So HIPAA actually came about way back in '96, Health Insurance Portability and Accountability Act. I will warn you, be careful of the spelling. It is commonly misspelled with two P's instead of two A's. That's one of my huge pet peeves. So there's only one P and there's two A's. So it's Portability and Accountability Act. And the initial reason for the rule was for the portability of health insurance. It really did away with the issue with regard to pre-existing conditions. If you had a person that was going directly from one job to another with a short break in between. Prior to that, an insurer would be able to say, oh, no, sorry, you had hypertension, you had diabetes, etc., even if there was, say, only a 15-day or a 30-day break between their insurances. And the Health Insurance Portability and Accountability Act actually stopped that practice. However, there were several elements within this act that put in place what was called an administrative simplification that moved forward some privacy and security elements that weren't acted on until much later, the 2000s, and then actually they were implemented later, 2002, 2003, but were very, very important to our industry. So the first one we'll chat about is the privacy rule, privacy regulations, the privacy rule, actually what that does is it protects obviously our healthcare information, and this is a federal rule, so it covers all information across the country. Although, if your state law has more stringent rules, then those rules would apply in your state. For example, I live in New York. Half of the time, Pennsylvania half of the time. New York has much more stringent rules on certain pieces of information, such as HIV related information, uh, behavioral health information. So in New York, for say my regular information that I would have at my primary care provider, that information would simply be covered under HIPAA. But if a person were to go to a behavioral health provider or go to an infectious disease clinic, perhaps where they're being treated for HIV, that information would be protected at a higher level than what is covered under HIPAA. So if your state has a more stringent guideline, it is preempted by that more stringent guideline. HIPAA is preempted by that more stringent guideline. The rule covers what's called covered entities. And covered entities are healthcare providers, so it could be a physician practice, it could be a hospital, could be a nursing home, those people that provide healthcare. It also covers health plans, so your insurers, folks like that. It also covers healthcare clearinghouses, so folks like billing services, the people that are kind of the go-between between the healthcare provider and the health plan. Now, what it doesn't cover are things like property and casualty plans, like progressive insurance, places like that. They are not considered covered entities under the privacy rule. It doesn't cover, for example, a police department. they are not a covered entity. Now, a fire department may be a covered entity if they have an ambulance service and they are providing billable services. So it can get very confusing under the HIPAA regulations. So it's very important that you examine yourself and make sure that if you're a covered entity or not. There are what are called business associates. So even if you're not a covered entity, you may be a business associate of a covered entity. So do you do work on behalf of a covered entity? You may be like an accounting firm or a consulting firm. I used to do consulting. So I was not a covered entity, but I did consulting. I did audits and whatnot. So I would have what was called a business associate agreement with covered entities, which meant that I had to uphold the same standards that other organizations had to uphold. I did HIPAA audits, so of course I would do that. So what is covered under HIPAA? What are we talking about here? So the privacy rule has what is called protected health information. And under the privacy rule, we're talking about any information. So it could be electronic information, it could be paper information, it could be oral information, so people talking to one another. Any information is covered under the privacy rule. And it's a pretty broad brush of information. So that we're not just talking about a patient's diagnostic information. It can be their name, it can be their date of birth, their social security number, anything that can identify that person. And what's important about it is that even if you say, I don't think that someone could identify that person from that. If someone down the road could possibly identify that person, oh well, that's the guy that lives on University Boulevard that had diabetes in 2017. If someone could figure that out, even though they don't have the name, then it could be considered a violation. So it's very important that all of the information is redacted from records if they're going to be shared, etc. So protected information, a very broad brush. And as you see on our document here, there are 18 identifiers that need to be removed if we are sharing information for some reason, perhaps research or whatnot. If there's no authorization for research, etc. So I won't read through those. You do have this in the classroom for you to review. So generally, this is a kind of a misnomer in the industry. Generally, a consent is not given for the use of information. What happens when you come into the practice or you come into a hospital, you'll sign what's called the Notice of Privacy Practices. So when I go into the hospital or I go into a practice for the first time, you'll be given a Notice of Privacy Practices, which is an indication of how they will use that information. And then I will sign off on that. So I'll sign off on that information, and then that organization can use my information for treatment, payment, and healthcare operations. They do not have to ask me again at any point in my care unless they make a change to their Notice of Privacy Practices to use my information for treatment, payment, and healthcare operations. So there is no consent that's required. There is no written authorization that's required for any of those uses. And that's kind of how this is detailed here. Now, oftentimes there's this kind of misnomer, misunderstanding that, oh, well, a physician can't share my information with my insurance company, or a physician can't share my information with another provider unless I sign an authorization. That's not really the case. Physician can share your information with another provider that you're seeking treatment from, as long as you've signed that Notice of Privacy Practices. That's within within that, as long as that's within the notice of privacy practices. If it's not, they've written a very poor notice of privacy practices. There are other uses that can be included in that that are part of the legal requirements, things like public health activities. Oftentimes, providers are required by their state law to report certain things like births, deaths. There are also typically mandated reporters if there's abusive situations, domestic violence. Uh, the providers are always required to submit things for licensures or disciplinary actions. And then sometimes, unfortunately, we need to submit information for law enforcement purposes. Now, there are very specific requirements around what can be submitted and what cannot be submitted for law enforcement. And law enforcement has to provide very detailed information before a provider can submit information. So if you are in the provider setting and you're ever requested to submit information for law enforcement, be sure to check with your own counsel before you're just handing information over to law enforcement. There's very specific guidelines about what can be and can't be submitted to law enforcement. Now, there are situations where an authorization is required, so you'll get that written authorization from a patient to submit information. So that would be if, like in the case of research, you need an informed consent. If you're sending records to a provider that's not providing treatment to that patient, maybe they're just reviewing records. If you're sending information to an attorney for some reason, you'll want to have an authorization. There are several situations where you would want an authorization. One thing that's very important about HIPAA is the minimum necessary standard. Providers, any covered entity, is always going to use, look at, etc., the minimum necessary amount of information. So we're only ever going to be examining the smallest amount of information that we need to for purposes of that business purpose that we're looking at. So, for example, in the electronic health record, I may have access to that entire record, especially when I was doing audits. When I was doing compliance audits, billing, coding, documentation audits. So I may have access to the entire record, but I may just be looking at a single surgery that was on August 24th. So I'm not going to look at that whole record. I'm only going to look at that surgery on August 24th. If I looked at that whole record, that would be a HIPAA violation. So it's so important that we only look at the minimum necessary information for that particular purpose. And I did spend a fair amount of time as a privacy officer, and we did run a lot of audit logs, and found we unfortunately fired a lot of people for surfing the electronic health record as their own personal Facebook or own personal internet. So it's important that you're only ever using the minimum necessary, and know that there is the ability to audit that, and if you are in the position where you can be auditing that, please do. It is a HIPAA violation to be examining beyond beyond the minimum necessary. So I am going to. There's a lot of other elements. I'll let you guys read through that. I do want to talk about privacy or security a little bit. You should have a privacy officer in place, and that kind of relates to security as well. You should have a security officer in place also. But I'll let you read through that other side. But the key to privacy is you want to keep information private and secure. You want to have your have your staff trained on security practices, and make sure that you have your business associate information in place. And the key is, what is the old adage, loose lips sink ships, or something like that. Just, only use the minimum necessary information, and make sure that you are, make sure that you're not surfing around in that EHR and not sharing information inappropriately. The security rule, on the other hand, this also came out of HIPAA, obviously. But this was specific to sharing or to protecting electronic information, so what they call EPHI. So the information that came out of the privacy rule was protected health information, PHI. What came out of the security rule was electronic protected health information, or EPHI. So the EPHI was specifically uh, what was coming out of our clinical applications, such as the EHR, computerized physician order entry, all of those systems like radiology, pharmacy, lab, etc. So these types of systems are, um, are so important to protect because there's so much data within them. And what the bulk of this rule was specific to not necessarily tell us, well, use the minimum amount of information, etc. That came out of the privacy rule. What the bulk of this rule was to tell us a little bit about how we might want to protect them. The compliance date with this was a little bit after the privacy rule, but still back in the early 2000s. So generally, sorry, I'm going to scroll down a little bit. Generally, the bulk of the rule described was that we were to develop some security measures that fell into these three different areas. However, it didn't say everyone needs to do these things, because if you think about the healthcare industry, you're going to have a wide range of organizations. You're going to have single physician practices that are going to have these types of systems. So one physician, two physicians maybe, that are not going to have a multitude of dollars available. And then you're going to have the UPMCs of the world that have millions of dollars at their fingertips to spend on these types of protections. So what this rule said is, everybody has some flexibility in how they make these determinations. So the first action that they asked people to do was to do a risk analysis and figure out where their risks were. Figure out where the risks were, where are things potentially going to go awry, and then make a determination on how to create reasonable security protections. Now, if you were to, kind of go to the agency that does all of the enforcement for actually both security and privacy, which is the Office of Civil Rights out of the Department of Health and Human Services, you'll find that the majority of the violations of the security rule, and there are many, all have started with the fact that the organization never did a risk analysis. They never figured out where their problems were to start. So they didn't have appropriate protections in place. So they say, do a risk analysis, find out where your problems are, and then they tell us to start with some administrative safeguards. So put things in place from an administrative perspective. Get security personnel, security management processes, etc., some training. Then they want physical safeguards. So this is literally like locking up your facility, being able to lock up your workstations, having policies and procedures in place. And this is about reuse of electronic media. You need to make sure you're wiping data off of electronic media. Make sure you're wiping data off your copiers when you're turning them back in from leases, wiping data off of those types of things. Those are your physical safeguards. But then your technical safeguards too. So things like your audit controls that we were just talking about, access controls like passwords, integrity controls. So those are things like electronic measures, making sure that there's integrity in your data, that data is not being corrupted, transmission security, making sure when data is being transmitted to off to your health plans, your clearinghouses, however it is, or back, if you are a health plan, back to your providers, making sure all of that is in place. So there's a multitude of different requirements. There's some basic information here in the document that's in the classroom, but it's just a matter of taking a peek at the info. There are some links that will give you some additional info you can click on if you have some interest in looking at the additional info about the security rule. But basically, what security rule is about is keeping the data safe, and it gives us a whole list of things that we can do. For example, one of the things that it talks about in the classroom is encryption. So encryption isn't required; it's suggested, because there are some facilities that may not be able to afford encryption. However, we're crazy if we send data somewhere and don't encrypt it at this point. So so those are the types of things that we need to. That's why we do this. Scroll back up here. Risk analysis. You need to measure benefit and risk. If we're sending data and not encrypting it, that's a huge risk. So that's part of that risk analysis. And that's a huge risk to our electronic protected health information if we're sending it via an open internet connection and not encrypting it. That would be a huge risk. So those are the types of the types of risks that we would need to analyze under the security rule. So hopefully that is a little bit helpful to kind of describe both the privacy and the security rule. Please feel free to contact me with additional questions. We are going to do a little bit of a Google Hangout to talk about Hipaa and kind of go over a few little case studies. Hopefully that'll be helpful. Hope to get that scheduled within the next couple of weeks here. And I will be seeing everybody in the discussion boards. Thanks.